Just let me know when you started, so. Good afternoon, everybody. We're just going to give people a minute or so just to come through the lobby. There's quite a few people joining.
Big one farming.
Oh, and if I could ask you to pop yourselves on mute if you're not presenting or speaking today, that would be amazing. So then we'll keep an eye on that. Right. Okay, I'm going to start if that's okay, everybody. Thank you very much. Good afternoon. My name is Richard Ayres and I'm a social care advisor at Care England, and I want to welcome you to our another joint Hempsons and Care England webinar. This one titled All Things Court of Protection for Social Care Providers. So today we will talk through the Court of Protection to help care home managers, senior leaders and clinicians navigate the capacity, best interest decisions, safeguarding disputes and restrictions on liberty. We know that's a really important subject for many of you today. We're proud to have Helen Claridge, a partner at Hempsons, to take us through today's session. Helen will introduce herself shortly and will clarify when and why providers become involved in the Court of Protection cases, highlight the regulatory and legal issues of getting it wrong, provide us an update on DoLS, DoLS pressures, and offer practical guidance to support lawful defensible practice in an increasingly complex and operational landscape. So we have taken on board the advanced questions that were sent through. I know a few more have come through, so thank you very much for those. And Helen is going to talk for just under an hour about everything Court of Protection, but would really like to take questions during the presentation. So if you would like to ask Helen a question or clarify a point, please use the chat facility to raise your question, and Helen will try to answer those as we go. Alternatively, if you want to put your hand up, we will pause for sort of a minute between sections to ask a couple of questions. Please make your questions short and succinct so that we can address them quickly. Alternatively, if you, because we are recording the session, if you do not wish to raise the question directly yourself, you can always send them to me by email, and I'll drop my email address into the chat for you shortly, and I will raise them on your behalf anonymously. I will ask you to keep yourselves on mute during the presentation, and as I said, Helen will use the full hour, so please help us to make this an interactive session by using the chat facility to give any comments or any thumbs up in the chat to avoid duplicating questions if that point is also relevant to you if it's been raised. As I say, we are recording the session, and our intention is, as always, to note any unanswered questions and to send an FAQ, presentation slides and a copy of the recording, hopefully within about 48 hours of the event. So without further ado, please let me hand over to Helen to introduce herself and to start us off today. Helen.
Thank you, Richard, much appreciated. And hello, everybody. As Richard said, my name's Helen Claridge. I'm a partner at Hempsons, and I specialise in the Court of Protection, the Mental Capacity Act and the Mental Health Act. So, and I work across a range of clients, NHS providers, trusts, ICBs, social care, care homes, residential domiciliary care, all of the above. So I am hoping to be of some assistance to you today. And as Richard says, but far nicer than I'm going to put it, if I'm not being of assistance, you tell me how I can be of assistance. I much prefer these sessions are interactive. I used to love the old sessions, you know, in person, when you can see what people are taking the points on, and when they're not hitting home, when they're not being helpful. Obviously we're not in that position today, so I'm relying on you to raise queries or to raise points as we go along. Because we're being recorded, I do tend to read them out loud so they can feature on the recording. So please don't think I'm stressing the point. I am simply trying to make it an effective tool for later on. So I do stress, please do bring things up as we go along, because the more interactive the better, as far as I'm concerned. As Richard says, this is our brief agenda, what the Court of Protection does and why. I promise I'm not going to give you a history lesson. I am going to take it back to basics, but only for a short period of time, just to make sure we're all speaking from singing from the same hymn sheet in that regard, and in terms of the terminology that we use. So forgive me if I'm teaching my grandmother to suck eggs in some of that, but bear with me, because I will move on, and I promise that won't be the bulk of the presentation. We're going to talk about real world risks of getting it wrong. The consequences of not grasping these things, and what the future holds, and how this may affect you and your business. I'm talking there about the liberty protection safeguards. We'll touch on that, and my latest intel in relation to those, and my thoughts and feelings about that, and top tips for navigating COP matters. That will go throughout the webinar. And as I say, please do raise things as we go along from your own perspective. I will not be giving free legal advice on specific queries as we go along, but on a no names, hypothetical, academic basis, I'm incredibly happy to, as Sir Richard says, deal with short, concise queries. I think we've covered that one in detail. Right, so what is the Court of Protection? The Court of Protection was created by the Mental Capacity Act 2025, and its main pillars are capacity and best interests. People talk a lot about the Court of Protection and what it does and who it's for and what framework it goes under. And there's an endless dispute about whether it's supporting an individual to make their own decisions, or whether it's a proxy decision framework whereby people make decisions on others' behalves. And there's a lot of back and forth on that point. But at its very core, what the Court of Protection does is it decides whether somebody can make a decision themselves, and if they can't, the court makes that decision for them. Its powers are to decide whether somebody, we always talk about P in terms of the individual at the heart of it, so I'll refer to P throughout, just because it's easier than repeatedly saying the person who lacks capacity to make the decision. So bear with me in that sense. But to decide whether somebody P has capacity to make a particular decision themselves, to make declarations, decisions, or orders on financial or welfare matters where P lacks that capacity, to appoint deputies to make decisions for P, to decide whether a lasting power of attorney or an enduring power of attorney is valid, and to remove deputies or attorneys who fail to carry out their duties. So in a nutshell, as I say, does an individual have capacity? If not, the court can make a decision. And if it's over a consistent period, or there's repeated decisions that needs to be made, or that individual wants somebody else to make that decision for them, the court can also step in relation to setting up those proxy decision makers and then policing them in terms of whether they're doing a good enough job or not. So that's why I say it's a decision-making framework, really. It's not always the court who makes the decision. Sometimes it is a proxy, as we say, but the court will police what that proxy is doing and how that proxy is behaving in case of any wrongdoing. Judges often sit in the family division, so they tend to be dual qualified in both and work over both. And the main court is in London, although courts can sit anywhere they want to. I've had courts come to care homes, come to hospitals, and it can be set up to do so. But the standard practice is in a courtroom, usually at a major hub, but sometimes on a further out hub. First question, will we get a recording of the webinar? We will do, absolutely, within 48 hours, that's the hope. So stay tuned, it will come to you. For cases concerning adults 18 plus, this is the Court of Protection's remit. Now, it can do some cases under 16 or 17, or sometimes those go to the family division. So typically for 18 or plus, but sometimes can be used for children 16 or 17. If under 16, then the court will be the family division. Clear rules, but largely intended to be inquisitorial. It's not intended to be an adversarial court. It's not meant to be he said, she said, cross words all the time. Now, for those of you who have spent any time in the Court of Protection, that you may sometimes have not felt like that, but it is largely intended to be a joint process to get to the right answer. So occasionally there are disputes, and of course those will factor in, but it is intended to be a sort of pathway to agreement on the whole. And the expectation is that the relevant statutory bodies, the local authority, ICB or NHS Trust, would be involved either as the commissioner or the provider of care. Can I please ask who can carry out these assessments? This is a question. Social worker, nurse, etc. Is there a legal ruling on this? Bear with me, I will come to it. We'll put a pin in it for now, but I promise I will deal with that point. So what does the Court of Protection do? Common applications include resolving disputes as to medical treatment, care arrangements, where a person lives and or who they have contact with. So if there's a difference in views in those things. authorising deprivation of liberty or challenging existing DoLS. We're going to speak a lot about deprivation of liberty and DoLS today, and determining whether P has capacity to make a specific decision. We talk about capacity as the gateway to the court of protection, because if an individual has capacity, then they don't need the court or a deputy or a power of attorney to make decisions on their behalf. They can make it for themselves. So it's only if the court or somebody else finds that the individual lacks capacity that the court of protection has any jurisdiction. If you are, I mean, I've been in proceedings a number of times when actually either somebody's improved or a more detailed assessment has been done, and the individual has been found to have capacity, at which point the proceedings are stopped. If there's agreement in that regard, proceedings are simply stopped and go away so the individual can make the decisions themselves. And removing powers of attorney or a deputy who's not acting in P's best interests. There's a question come in about what you need to do in assessments. And again, I'm going to put a pin in that. We'll come to it, I promise. I'm going to whip through the terminology first, and then we'll get to the nitty-gritty. The key terminology here, I mean, I think the DoLS, like anywhere, is full of shortenings and shorthand, and I just want to make sure we're all on the same page in this regard. I'm not going to go through the slides in detail. You will get the slides, as I say, and the information is on there. But lasting powers of attorney, be careful about the type. Some people think if they have one power of attorney, then they can make decisions ad infinitum about the individual, and that's just not true. So if somebody comes into your organisation and says, "Oh, I've got a power of attorney for this person," the first question is, "Great, that's really helpful. Can I see it?" You know, I know that some people take offence of that, but blame the lawyers. You know, you need to see it because they are different. They cover different things. Is it property? Is it health and welfare? And is it, you know, under what parameters is that individual allowed to make a decision for P? It might be that they're only allowed to make a decision in conjunction with somebody else, or it might be that they can do it alone, but the remit of the decision is limited. For instance, you could I've seen a number of power of attorneys that say, I want this individual to make my health decisions for me, unless it's life-threatening, in which case I want the doctors to make it for me. I don't want my power of attorney involved at that point. I always talk about if I was really playing havoc with my own power of attorney, I'd make it so that my husband and my mother have to make decisions jointly, instead of separately if anything were to happen to me. And it's a thought that keeps me amused in the dark nights, because I can only imagine that would result in complete chaos. Anyway, they also must be stamped. If you get a power of attorney that is perfectly filled out and indeed signed, it does still not convey any decision-making power unless it is sealed by the Office of the Public Guardian, and that seal will be on every page, and you need to see that. You need to see that seal. You must see the LPA in full for all of those reasons. I've put EPA on there. You are still seeing EPAs. EPAs were the predecessor before lasting powers of attorney, and EPAs are a bit different in that they can be valid before they come into effect when the individual loses capacity, rather than sort of being in effect to be used once the individual lacks capacity. So as I say, if you see an EPA, just be a bit cautious, because it will be. You can't make an EPA anymore, but the ones that were made pre-LPAs, which was early in the 2000s, are still valid if still around. Deputies. Appointed by the Court of Protection. So a deputy is essentially a power of attorney that's appointed by the court rather than the individual. That's how to look at them. They also have two types: property and affairs, personal welfare, and deputies must, like power of attorneys, follow the MCA principles, make decisions in best interest, and have regard to the code of practice. They can only make decisions in line with their authority. So again, if you come across a deputy, the first question is, very good to know, can I see the order, please? Because I need to understand the parameters of your power. And again, it shouldn't be an insulting question. If they're a legitimate deputy, they should be familiar with providing the basis on which their decision-making power is given to them. So deputies and LPAs, very, very similar in terms of they bring about somebody who can make decisions for P. But I should add that they are both subject to best interest considerations. So they are not a complete proxy decision maker in that they can make any decision for P that they consider. They have to act in P's best interest. So there's still that overarching requirement to act in best interests. Whereas I, making my decisions on my own half, I don't have to act in my best interests because I decide my own best interests. But if I lost capacity and my husband and indeed my mother were making decisions under my LPA, they would have to act in my best interest. So it brings a slight objectivity to it, but it's worth bearing in mind. Office of the Public Guardian. Registered powers of attorneys, and it's before the individual loses capacity, they must be registered. Supervises deputies as well, and investigates concerns of abuse or wrongdoing for either. I mention the OPG because if you have a concern about a deputy, if you have a concern about a power of attorney, then the OPG website is the correct place to register that concern, and they will investigate as a first port of call. And advance statements and decisions. I've put these in. I'm not going to go through them in detail, but this is another way by which somebody can advance plan for when they might lose capacity. I can do an advance decision that says if I ever were in a prolonged disorder of consciousness or something, I wouldn't want to continue artificial nutrition and hydration in those circumstances. Or I can say that I don't want to be resuscitated if I was ever to have a cardiac arrest or something like that. And those are legally binding if completed in the same way. Advance statements are just an expression of wishes. They are not legally binding, but they are to be taken into account in a best interests forum. Right, I'm going to turn to some of the questions now before we go on to deprivation of liberty. Can I please ask who can carry out these assessments, i.e. social worker, nurse, etc.? Is there a legal ruling on this? And I'm assuming that's capacity assessments. There's guidance on who should carry out capacity assessments, but the general rule is that they must be able to do so. Now, I see a lot of challenges, concerns, disagreements about who it is appropriate to do a capacity assessment. There's no requirement, for instance, that a psychiatrist does a capacity assessment or a psychologist does a capacity assessment. That might be necessary in certain circumstances, but it's not a hard and fast rule. And if there's a capacity assessment in relation to contact, in relation to tenancy agreements, in relation to care at the placement, it's whoever can talk about that in an informed way, providing the right relevant information, and has the skills and experience to understand what they're assessing in terms of whether that individual can understand, retain, weigh, and communicate that decision. So I hope that's helpful. If it's not, let me know and we'll delve further. Should each restriction where a person is subject to have a mental capacity assessment and best interest decision for each locked or covert meds, walking harness, 2-to-1 supervision 12 hours a day? I keep seeing care provider just completing one MCA and best interest decision for all restrictive practices. That brings us very nicely onto our deprivation of liberty issues. Which I will tackle here. Just stressing the LPA. I would keep a full copy of the LPA on the person's file. Yes, I think it is helpful, and I think if you only start saving pages, it's problematic because some of the different pages are key to different things. So I would keep a full copy of the LPA on file, and I would say to the attorney, if it changes or if anything changes from your perspective, do let us know, because I think it is helpful, and through changes, it's useful to know what's been decided previously by the individual and what the decision-making remit of that power of attorney is. So I hope that helps. Right, let's come on to deprivation of liberty and whether we need all these numerous assessments or whether we not. But at the basis, let's do a brief section on the criteria. I promise I'm not going to labour this point because I know you will all have seen this numerous times. But 3 elements: confinement in a particular restricted place for a not negligible length of time. I mean, I apologise for lawyers everywhere for the number of negatives in there. And that's the acid test. Is the individual under continuous supervision and control, and are they free to leave? If they are under continuous supervision and control and they are not free to leave, then they are likely deprived of their liberty. If there is a lack of valid consent, i.e. they're not consenting to it themselves, or and it's also the responsibility of the state. I have to be very cautious with the responsibility of the state because it's such a low bar. So it is as we all know. Key questions. Does P lack capacity? So this is the real world questions. Outside of the legal criteria, what questions do you need to be asking yourselves within your organisations when you are taking a view on whether somebody is deprived of their liberty? And they're set out here. Does P lack capacity to make decisions about care and treatment? It's green, so you need a yes to that if you're heading towards a DoL. Is P subject to continuous supervision and control? Yes. Now that doesn't necessarily mean somebody's eyes on them at all times. If there's some sort of technology or equipment to make sure that there's ongoing monitoring, even if they're not in eye line vision, then that will feed into that continuous supervision and control as well. And is P free to leave should they wish to? Now, leave in that sense is leave as in could they get up, pack their bags and move out of their own volition? If they couldn't, then it points towards a deprivation of liberty. Looking at the concrete situation, so a pragmatic view in relation to those criteria. You'll have all heard, I'm sure, a gilded cage is still a cage. It doesn't matter if there is no intention to lock up. There is, and the individual is perfectly content with the level of care, and indeed, welcomes it. That's all irrelevant. It is the hard and fast facts as to whether they're under continuous supervision and control, and whether they're free to leave, and their own contentedness with the situation does not factor into it. Not all restrictions on liberty will be a deprivation of liberty. It is a scale. It is a scale, and this is not black and white. And all of these things here are things which I come across very regularly in people assessing whether something is, whether an individual is deprived of their liberty or not. So locked doors, the level of supervision or observation, sensory mats, CCTV, bed rails, epilepsy sensor. All of these in isolation are unlikely to be a DoL on their own, but if you amalgamate them all, if you put them all on top of the other, or there's a number of them, then they point towards a deprivation of liberty. Let's have a look at the questions for a second. The MCA applies to people over 16, but the COP usually only used for decisions for people over 18. Not sure why. Yes, it's you and lots of people. I've been in lots of cases for 16 and 17-year-olds where CAFCAS, who act for the child, and the official solicitor, who would act for the adult individual, are rowing over whose job it is to be in there, and that also goes to the point of which court, because it's CAFCAS, it's family, and if it's the official solicitor, it'll be in the Court of Protection, and the end of all of these disputes is always, is it going to be a long-term issue? If it's a 16-year-old who's likely to need, it's a one-off medical procedure, and they need the court's authority to do it, then it is likely to stay in the family division with CAFCAS. If it is a 16-year-old who it's about their residence, about their care, where they're going to be in the long term, and the official solicitor is going to need to take a view on that on behalf of that individual, then it is more likely that it will be in the Court of Protection, because then it will be able to see it through for the life of the individual. But as I say, it's not a hard and fast rule. There's lots of dispute over it, and it tends to be the choice of the applicant where they issue for 16 and 17-year-olds. I suppose that the story to take from it is for 16 and 17-year-olds, you can do either, then legal advice will be taken on which is more appropriate. So it's not that it excludes one or the other. They both are available, I suppose, is the outcome. Maybe a stupid question. Can you talk about deprivation of liberty in the multiple as DoLS, or does that indicate that you're talking about deprivation of liberty safeguards? Oh, I mean, it's not a stupid question at all. It's one of the reasons why I hope the LPS might come in, because we can stop talking about DoLS and everything's DoLS, isn't it? But you can absolutely talk about deprivation of liberties, I suppose, but it does confuse it with DoLS, as in the safeguards. How I do it, which I'm not saying is necessarily the right answer, but little s means plural deprivations of liberty, big S means safeguards, but I can safely say it's not consistent across the board. So just be careful. No, it is something that people get wrong regularly. So be careful when you're reading something, and don't be afraid to clarify with somebody. You know, can I just clarify we are talking about the safeguards, or are we talking about multiple deprivations of liberty? I think it's an entirely reasonable question, just to make sure everybody's on the same page, because I think failures in communication are incredibly common when it comes to the Court of Protection, and the sooner they're nipped in the bud, the better. Isn't it the case that CCTV or sensors, for example, aren't a deprivation, but the action taken as a result of them is, e.g., a door sensor triggers sending someone to stop someone leaving? It's an interesting perspective, and I think it goes back to this point here: continuous supervision and control. If the only restriction that somebody has is that they have a door sensor, which communicates to somebody that they're going out of that door, is that sufficient to be a deprivation of liberty? I would say no. But if they have that door sensor plus a sensor mat on the bed, so somebody knows when they're not, and some CCTV in the kitchen, and somebody comes in however many times a day, then we're getting more and more towards a deprivation of liberty, I would say. So, as I say, a door sensor, I would suggest, in and of itself alone, would not get you across the bridge to the deprivation of liberty. But if it is in conjunction with a high level of observation via other means, then it is something which adds weight to that being a deprivation of liberty. I hope that helps. Let me know if not. Great. I think we've covered the questions for the moment, but do keep them coming. So what happens there? Once we've established our DoL, that being a deprivation of liberty, what needs to happen? And the law says that needs to be authorised, and there are a number of ways for it to be authorised. And the law says it needs to be authorised because it's a high level of restriction, because it's a vulnerable individual. Then there needs to be those safeguards in place to make sure that it's not arbitrary, it's not punitive, and it's in their best interests. So it's the authorisation of the DoL is intended to add that safety netting in to make sure that there is that consideration as to whether something is least restrictive. That's the basis behind needing the authorisation. And there's three ways of authorising it: deprivation of liberty safeguards, the DoLS, Mental Health Act, order of the court. Obviously, the deprivation of liberty safeguards is our most common one in terms of care homes and hospitals, and then order of the court if we're talking about deprivation of liberty outside of those two environments and in the community and perhaps in a supported living setting. Let's get on to when I might be involved in the COP. And I'm going to deal first with care homes, because as we say, you know, it's a very clear distinction with the deprivation of liberty safeguards, that it attracts to the location of the person. It's very geographically based, rightly or wrongly, and I have my own views, but rightly or wrongly, and it will only attract to hospitals and care homes. Dealing first with care homes, completing the urgent authorisation form for a DoL. So if you have an individual at your care home, you consider they're under a DoL, complete the urgent authorisation, self-authorising, and you apply for a standard authorisation simultaneously, declaring that in your assessment they lack capacity, they're under continuous supervision and control, they're not free to leave, and the deprivation is imputable to the state. Again, very low bar on that one. And in circumstances where an authorisation is in place, obviously we know that P, the family, or the RPR, the relevant person's representative, on behalf of P, are objecting to a DoL, then that should go before the court under a 21A application. Other circumstances in which you might be involved in the Court of Protection from a care home's perspective is by way of a third-party disclosure order. So you get an order saying, we need these records from you. There's active Court of Protection proceedings, and we would like these records from you by this date. I don't know how many of you have seen orders like that, but they're very common in my practice, and they cause lots of problems. So I'm going to talk about those in detail shortly, but we'll move on to consider the alternative, i.e. outside the care home environment. So if you're from a supported living placement or a domiciliary care provider, when would you commonly end up in the COP, as far as I've seen, and it's when that deprivation of liberty authorization is required. You can't use DoLS, so an application is put in by the local authority or the ICB. You're not required to put the application into court, but it's a paper-based exercise that goes to the court to say, there is a deprivation of liberty, we believe, in this residence. We consider it's in the best interests. It can't be authorised by DoLS because we're outside of the care home or a hospital, but it still needs authorisation. Court, can you please authorise it? And in order to do so, you will be expected to liaise with the local authority or the ICB to provide care plans, probably contribute to best interest discussions, and have your view recorded on the Annex B, and to generally be available and responsive in relation to the progress of that application. Usually, if everybody's in agreement, they can be done on a paper, i.e. don't need to have a court hearing, but sometimes a court hearing is needed. For instance, if the family member's not happy with the level of care or with the level of restriction, or thinks the individual should be elsewhere, then it might need a court hearing, and then you might be brought into that in some capacity. What if P or their family object? Now, this is the most common route by which the Court of Protection is involved for an individual with capacity when we're talking about these challenges, and it's because either the individual doesn't want to be there, has expressed a wish to leave, or the family are in a dispute about the level of care or the place or funding, and it goes before the court. The court proceedings for these Section 21A challenges against the DoL name the local authority, usually because they have overall oversight of the DoL, and will often bring the ICB in as another party, for instance, if the ICB are funding any part of the care package. I say this here, it is very rare for the provider of care, you, to be named as a party. It used to be, when we started doing these 21As, it used to be that quite often the provider would be named, just because, I mean, there is, looking at it theoretically and academically, out of all the people, you tend to know P the best. So you would be helpful to have in the court proceedings, because you can feed in as to their most recent presentation and how you care for them. But people very quickly came to realise that these Court of Protection proceedings are incredibly expensive, or at least they can be. So providers obviously weren't keen on spending their cash on lawyers for processes, no matter how well intentioned those processes were, and it resulted in a lot of refusal of placements and things like that. So a pragmatic view has been taken, and is now widespread, that providers don't generally need to be joined as parties to those proceedings. So it's not that you are being excluded, it's not that you are considered not to have an important role to play in P's life. It is that it is yet another cost, and one I suspect you would not choose to bear unless you absolutely had to. P themselves will be funded by legal aid because it's in relation to their deprivation of liberty, and there's a very low threshold to start proceedings. P objecting, P wants to go home, P asking to leave. In my experience, a lot of these applications are not, I was going to say not necessarily well-founded, and I don't mean that. I mean that they're not necessarily logically founded, in that, for instance, one case I've got at the moment is an individual who keeps saying he wants to go home, and he's very consistent in his view that he wants to go home. But what he really wants is to be 20 years younger. That's his real wish. He wants to go home, and he wants to operate his farm like he always did. he doesn't really want to go home and be subject to the same care and restrictions that he's currently subject to in order to keep him safe. But that it doesn't. The reason why somebody objects to their care is not considered by the court. It's not considered to be an unreasonable wish to return home, even if it's founded on a slightly incorrect or not quite complete assessment of one's own needs. But as part of these proceedings, the local authority or the ICB, i.e. the commissioners of the package or the ones with oversight of the DoLS, will draw up a balance sheet of analysis of care options for P. If they want to go home, is it a realistic alternative? Is it available to them? And is their view that it's in their best interests? And these proceedings, some of them result in just a tick box that says, no, we're happy that the care provided is entirely appropriate and the placement's meeting his needs well and is least restrictive, and that the alternative is not available. Or sometimes there is a move that's made. It depends on how the court views it. Court is a vehicle to keep the review on track, often no need to attend court in person, sets a timetable. Starting point is checking capacity, as we say, that gateway provision, and establishing P's wishes and feelings, including any relevant historical background, condition and prognosis. The local authority, ICB, prepare the balance sheet analysis of options, and roundtable meetings or best interest meetings take place in order to collate the evidence and then put it before the court. I will say that there tends to be a fair few hearings listed in the Court of Protection, and not many of them are actually used. A lot of them are agreed away in the end because people can reach an agreement. As I say, this procedure is meant to be largely inquisitorial, so we all meant to be on the same side, i.e. the side of P, and quite often you can agree to say, oh well, we will provide a further statement dealing with this issue, but then we don't need a judge to tell us that. We'll just agree to do that, so we can agree that and tell the judge that that's what we're doing. Those do tend to be fairly regular occurrences. RTM or best interest meetings are usually online. Home manager, P's key worker, carer who knows them well should attend. For these RTM meetings, which are round table meetings for the avoidance of doubt, it's just a fancy word for meeting really. They're usually done via Teams now, as opposed to at the provider. We used to do them all at the provider, which was actually really helpful because you could see the care environment everybody was talking about. But as I say, they're all online now, which makes it easier. And if you are invited to a Court of Protection round table meeting, I do advise that you attend because usually they're an hour long. They're not incredibly onerous, and I think there is a huge benefit in staying informed. And more often than not, you are not in trouble, but you are a useful source of information and logic about P. Because you will appreciate that the basis for these proceedings is the local authority and somebody who perhaps professionally is required to act for P. So it may be that neither of those parties know P terribly well, but they're still actioning quite an important proceeding on their behalf. So I think it is always incredibly helpful when someone from the provider turns up to say, oh, this is how they are this morning. This was how they were yesterday. We understand that when you met with them, this happened. This was in the context of this. Just to provide a bit of background and a bit of person-centered consideration really to that meeting. I think it's a really helpful addition, but I do appreciate it takes precious time. But for me, it's always a helpful addition. Restrictions on P are supposed to be at a minimum level. That's a court-accepted principle. Many DoLS challenges relate to P not being supported to engage in the community. As a provider, look at each resident and whether they're living their best life. What other activities could be in place for them? Could they be supported into the community more? That's always a big point of the official solicitor when they're acting for P. Are there enough activities? Are attempts to engage in activities ongoing, even in the face of reluctance, let's put it that way, or do they have sufficient access to the community? And if you feel as the provider that you don't have the funding in order to do the job you should be doing in those regards, then do make that seek that support to access the funding, because in my experience, local authorities and ICBs are fairly responsive to that, because it will evolve continuing the DoLS challenge in the court, which does cost them money. if that's a good resolution. Ultimately, you may find P moved from your service. You may be asked to support P in visiting other services and preparing transition plans. You might be asked to prepare a statement around P's activities, but you will be supported to do this, and you shouldn't need to incur any legal costs. You will be asked to share copies of P's care plans. Stay in touch with the social worker case manager so you know what's happening. And again, there shouldn't be any need for the provider to be joined into court proceedings, and it would be very rare that you need to attend court. So I think in summary, your position, in my experience, with these challenges in relation to the DoLS orders, be that the deprivation of liberty safeguard orders via way of Section 21A challenge, or the COP-DOL 11s in the community and any hearings that result from that. As I say, I see your involvement as really helpful in order to inform them, but there shouldn't be any need for you to spend the money on legal advice, but do engage with them as you can in relation to the documents that are requested and and attending meetings, because by doing so you come across as a transparent and helpful provider, and that goes a long way to assuring the court that you're acting appropriately in relation to this individual's care, because that's essentially what they're looking at. Could you be dragged into the Court of Protection as a result of disputes over hospital discharges? Potentially. Again, it's another potential, and it's another one where I say keep your lines of communication open. We see a lot of disputes about discharges from hospital because the family won't agree to the placement and what to do. One route out is for the local authority or the ICB to apply to the Court of Protection for an order that is lawful and in P's best interest to move to care home 1 or another location. Again, there should be no need for you to be a party to proceedings, but again, stay in touch with the public bodies as to the plan, especially if you're being asked to keep a bed open, and the financial consequences of that, I'm sure you will address. Care at home disputes, does the Court of Protection deal with those? And the answer is yes. P lacks capacity, cared for at home, family interfere with the package, service breaks down, what to do? Again, another route out, if it's not resolvable via alternative means, is for the local authority or the ICB to apply to the Court of Protection for an order that it is lawful and in P's best interest to be removed from the home and replaced in a care home or alternative accommodation. Again, you don't need to be a party, but stay in touch. So you will see there is a theme here. Now, we talked earlier about third-party disclosure orders, which can look absolutely terrifying, and they arrive on your doorstep or usually via your computer, saying we need all of these records and we need them yesterday. I see a lot of providers who send these to me and say, do I have to follow this? Because it's asking an awful amount, and I don't know how we're going to do it. What I will say is these are very common, but in my experience, often not sufficient thought is given to them, and some people put quite a wide-ranging order in. So we'll say, we want all records from your organisation as long as you've known P, or we want all records you hold in relation to P. And if you've had this individual for many years, that is a overwhelming amount of documentation, and I've had providers come to me saying, if I have to photocopy all of this, it will take 3 weeks and 5 members of staff working all the time. I can't afford that. I can't afford the time and I can't afford the staff. What can I do about it? And the answer is I hope reassuring, in that you can go back and say, look, this, if you want me to do this, it will take this amount of time and this amount of time. What are you looking for? Because actually the likelihood is it will be somebody who has written the order very quickly just to say, oh, we need something from this provider, let's just ask for everything and we can filter out what we need, without really appreciating the extent of the records you will hold. So actually, by writing back to them and saying, this is the extent of the records we hold, I'm pretty sure you don't want everything, can you let me know what you do need, and I'm happy to help. So engage early on, see what they really need, and see if you can limit that order to a reasonable a reasonable requirement, is my advice in relation to it. Engage with it early. Don't put it on a heap and forget about it, because the parties in the court will be a lot more amenable to something which says, this will take me so long, can I give you this instead, if it's done immediately, rather than when it's already overdue by 2 weeks or 3 months. I'm going to have a quick look at the questions. Can people with capacity consent to what would be considered a deprivation of their liberty? Yes, they can, really. If we go back and look at our, is the simple answer. If we go back and look at our lack of valid consent. So if an individual wants to live somewhere and wants to receive the care that means that if they lacked capacity, they would be under continuous care and supervision, the law says they can do so. And that is why the capacity is one of the big assessments under the deprivation of liberty safeguards. If you're looking to detain somebody who has capacity, we're talking about the Mental Health Act, which is obviously an entirely different legal framework. So the quick answer to your question is yes. Can providers get third-party costs covered? I know many who have to pay for staff and copying, etc., and they have it covered by lawyers for COP and COP itself. It is not much, but all costs and staff time has been covered, so demanded. I mean, all I can say is ask. It is difficult to know where the money comes from, but if it is an onerous documentation requirement, the court has considered that it is absolutely essential to have all of that documentation in order to resolve an issue, and you cannot possibly meet that requirement without X, Y, and Z in terms of additional staff, additional funding, then ask. Because if you don't ask, you don't get. I am not guaranteeing that it will always come, but you should be given some you hopefully will be given some support, some assistance, either in terms of making the request more reasonable, more doable, or in making sure that you can meet it. Because if the court has required that it is all that essential, then hopefully that is grounds for that argument. We did this for 6 years of info. We offered a year with a view that once they had seen how much it was, they didn't ask for more, and we were right. Great. You see, I'm really pleased. I'm really pleased. And if you take nothing else away from this talk today, take away this point about third-party disclosure orders, because people do get a sealed court order with a stamp on which says the justice has considered this and we need A, B, C, and D, and they think, oh, crumbs, I'm going to have to do all of this. And actually, there is some wiggle room in terms of how much you need, and actually, the court proceedings have to be proportionate and as is necessary to the circumstances. And if they want all of that if they want a huge amount of records, they should be asked to say why. Question: are you aware of instances where the local authorities are the ones not following the process or reluctant to do so? We have noticed this in our location. It's a very leading question, and I'm mindful that I'm being recorded. I think it is apparent to anybody practicing in the Court of Protection that local authorities are under a huge amount of pressure. And certainly in relation to deprivation of liberty safeguards, obviously the assessment process, the authorization process is famously backlogged for good reason. The Cheshire West decision on what constituted a deprivation of liberty just meant that so many more people were deprived of their liberty than was considered to be the case before that judgment. So I hope that answers your question in terms of what the local authorities are doing. What I will say is that everybody knows the local authorities are incredibly pressed, but the argument of they never take any notice of us, so we didn't do it in this case, does not go down well in the Court of Protection. So I know that sometimes it may feel like sending your requests into the ether or into the void, never to be seen of again or heard of again. But it's the case that you don't follow up or that you don't make that initial contact that will inevitably get the scrutiny of the court, and you will kick yourself for having done it in 95% of cases and then not in this one. So as I say, it is well accepted that the strain local authorities are under and the consequences that has on the exercise of their responsibilities, but don't let that impact on your own responsibilities. I hope that's helpful. With fluctuating capacity, do you need an expert to do the determination of capacity given it's more complex or not? Good question. Fluctuating capacity is notoriously tricky, and there are two different ways that the courts deal with it. One is to decide that if somebody has fluctuating capacity, they always lack capacity, and they're to be taken as such, which obviously is not consistent with least restrictive, but it does have the advantage of being a relatively simple mechanism and a simple resolution. The other way is to say, we know that this individual has fluctuating capacity, so they can make decisions when they have capacity and they can't when they don't, and will perhaps make some orders about the situations where they don't have capacity. But of course that puts an awful lot on you as the provider in terms of working out when somebody has capacity or doesn't have capacity, or whether they're just cross or energized or heightened, but they do actually have capacity, or whether it's again the fluctuating capacity. So there is no uniform way of dealing with that via the courts. In terms of whether you need an expert to take a view on capacity, fluctuating, there's no blanket rule that says that for fluctuating capacity you need a consultant psychiatrist to do it. There's no absolute requirement of that. But if you are dealing with a case of fluctuating capacity and it is causing problems on the ground in terms of your managing it, there would be good reason to escalate the assessment and the planning accordingly. Now, I'm not saying you need to do that, or you need to instruct that expert view yourselves, but it might be worth raising that and considering it, and whether that can be whether that is needed for a complex case. I think the basic rule applies. The more complex case, perhaps the more evidence of skill, experience, qualification needs to come to the table, so that you can demonstrate that you've recognised a case for its complexity and you have taken action appropriately. I hope that helps. Is there a chance that there could be changes to the amount of time that DoLS or COPs last for to elevate the amount of pressure on local authorities? So we're going to come on to changes in a minute. Are we going to come on to changes now? We're not going to come on to changes right now. I'm going to put a pin in that for a second and I'll come back to you, I promise. We're going to deal first with that with risks. I'm mindful that I'm coming to the end of our time, and I'm sure I don't need to drone on about the risks. Regulatory, CQC, they are very fond of assessing restrictive practices and making sure that the appropriate safeguards in place. Legal, we've talked about the potential for getting dragged into legal proceedings if documentation isn't provided, or if you are not providing the information that's needed. And there is every reason why you are able to keep out of these COP proceedings, as long as you're being transparent and helpful for those that are in the proceedings. Financial and reputational, I'm sure I don't need to stress the risk of a judgment. These cases are now usually held under a transparency order, meaning they are in public court or with public access, and they can be reported on by the media in some cases with certain restrictions in place, but the impact on a provider of being named in proceedings such as these can be significant. Top tips. These are my top tips, which are just pulling together what we've already talked about. Good knowledge of the basics and the principles: capacity, best interests, deprivation of liberty. Know your terminology and know when to escalate concerns. It sounds from the questions as though that's absolutely already been taken on board and actioned. patient-centred care and timely assessments to bugbears of the Court of Protection. If you can demonstrate that you're doing that you have the required priority for these things, then you're halfway there. Good communication, timely acknowledgement of any court orders, and attendance at meetings if invited. As I say, keep in touch with the local authority, with the ICB, in relation to any proceedings which are ongoing, and do respond to any requests for information. Even if you can't meet them, be clear about that. Be transparent, because that, as I say, that can be dealt with. And escalators needed. Do ask for help if you need. As I say, hopefully there are only incredibly limited circumstances in which you need to be dragged into these proceedings, but do feel free to escalate with your own organisation, obviously, and to seek outside help, including legal assistance, if needed. The future of DoLS, as we say, are we going to be changing the time that they last for to try and alleviate some of this pressure? The liberty protection safeguards were drafted and have been set out in law, and they were designed to feel more positive than negative. The reviews of the wording are not overwhelmingly positive, but there are certainly positive indications from it. They apply for 16 or over, not just 18 or over, like the current DoLS. They lack capacity and has a mental disorder. The future of these is uncertain. In April 2023, it was commented that the LPS were going to be delayed beyond the life of this Parliament, and I think towards the middle of last year, everybody thought that they were dead in the water. But then we heard at the start of November, end of October last year, that there would be fresh consultation in 2026. Came in tandem with the case before the Supreme Court about what exactly constitutes a deprivation of liberty, and we're still waiting for that judgment. So we anticipate that those will go hand in hand. Will they be better for you on the ground, the LPS? Quite probably. Who will have to do what? The responsible body for P, if P is CHC, it will be the ICB. So it's limiting the currently large role of the local authority and spreading it around a bit. Whether that will improve response times or improve pressures or make them worse, again, it remains to be seen. There are, under the current wording of the LPS, there are potentially significant obligations on care home managers in terms of providing statements and evidence in consultation. But we just do. The answer to when they're coming in is the answer to if they're coming in is we just do not know. I suspect it is more likely than not now that they will come in, because we have been promised this fresh consultation. And what can you be doing now in relation to those? The first thing goes back to my original top tip: know the basics in terms of capacity, best interests, because those won't change. So know that, so that if change does come, then you're sure on the foundations for when that change takes place. And what else can you be doing now? Feed into that consultation. If and when it ever arrives, do feed into it. Do make sure that your views go into consideration for how those LPS, if they do ever come in, feedback, because by doing that, hopefully you can ensure that the next round is informed by things on the ground, so that they are sensible, pragmatic, logical, and achievable when they do come in, rather than another framework which arguably does not do those things. I'm just going to have a look, see in the questions. In a care home environment with mainly people with dementia, how to assess capacity, person who does not have an appropriate diagnosis. Non-appropriate diagnosis. I mean, there is a diagnostic element of the capacity assessment. You're absolutely right, but it doesn't require a formal diagnosis. In terms of it can, for instance, alcohol consumption or somebody being unconscious is sufficient grounds for the diagnosis. I mean, there was a case recently where the judge said that just because somebody had been in ICU for a long time, and that was bound to, I mean, he didn't phrase it like this, he put it far more eloquently, but it was bound to drive anybody round the twist. that was considered sufficient for the diagnostic test. So I would say, in relation to that question, do not get too hung up on a formal diagnosis. If they're, you have to demonstrate an impairment of the mind or brain in order to satisfy the diagnostic test under the Mental Capacity Act. So if there is evidence of that impairment, then that will assist. Right, I think we have come to the end of our time together. 1 minute to go. I'm conscious that Richard said I would talk for nearly an hour, and I think I've come in pretty much exactly under that. So as Richard says, he will collate any questions. If anything further is needed, do let me know. Hempsons do run a free social care advice line. That's the number there. If you have any DoLS queries, do feel free to give us a bell. And it was nice to discuss with some of you. Again, I'm sad we don't do this in person, because it would be nice to meet you. But I hope the session was good. And if it wasn't, constructive feedback is much appreciated, because we will do better next time if not.
Thank you, Helen. We've had fantastic feedback. People are really very chuffed with it, and I am as well. You covered so much ground. Thank you so very, very much. We are going to have to draw the event to a close, but we can also host another one. So if more questions come through that need to be answered, we'll definitely set up another session. But a big thank you to you. Lots of claps there, Helen. Thank you very, very much for your time. Thank you, everyone, for joining.